Good morning. We will continue with the remaining portion of Module 3, Constitution of India in this presentation. And these are the content. Attorney General of India, highest law officer defined in Article 76 and 78. The Attorney General for India is the Indian government's chief legal advisor and is primary lawyer in the Supreme Court of India, who is appointed by the President. He should be a citizen of India and a judge of some high court for 5 years or an advocate of some high court for 10 years or should be an eminent jurist in the opinion of the President. The 15th and the current Attorney General is K.K. Venugopal. The Constitution does not provide for fixed tenure to the Attorney General, so he holds office during the pleasure of the President. He can be removed by the President at any time. There is no procedure or ground mentioned in the Constitution for his removal. He gives advice to the Government of India on legal matters which are referred or assigned to him by the President. He discharges the functions conferred on him by or under the Constitution or any other law. He appears on behalf of the Government of India in all the cases in Supreme Court in which the Government of India is concerned. He appears on behalf of the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. He appears on behalf of the Government of India in any case in a High Court in which the Government of India is concerned if the Government of India requires so. Next, we will see the Parliament, which is defined in Article 79 to 122. The Parliament of India is the supreme legislative body of the Republic of India. It is a bicameral legislature composed of the President of India and the two houses, namely the Rajya Sabha and the Lok Sabha. Both the houses have elected as well as nominated members. The elected members of Lok Sabha are elected directly on the basis of voting. The elected members of Rajya Sabha are indirectly elected by members of legislative assemblies of states. While 2 members of Anglo-Indian community are nominated by President in Lok Sabha, 12 members who have excelled in various fields such as art, literature, science, social service, etc. are nominated by the President in Rajya Sabha. The term period of an elected member of the Rajya Sabha is 6 years, while the same for an elected member of Lok Sabha is 5 years. As per Article 84 of the Constitution, a person is qualified to be a member of the Parliament provided he is a citizen of India. He has completed 30 years of age in case of Rajya Sabha and 25 years in case of Lok Sabha. If he possesses qualification prescribed by or under any law made by the Parliament, if he is a registered voter in a parliamentary constituency and must be eligible to vote. It is not necessary that a person should be registered as a voter in the same constituency, and this is applicable for both cases. And if he is a person from reserved category, he can contest election if the Lok Sabha seat is reserved for these categories. However, an SC/ST person can contest election on an unreserved seat also. The Constitution of India has provided that a member of the Parliament will be disqualified for membership if he holds an office of profit under the union or state government. He is of unsound mind and stands so declared by a court. He is an undischarged insolvent. That means a court observed that an insolvent is a person who is unable to repay his debts, and as long as he remains in that position, he is an undischarged insolvent. So if he is an undischarged insolvent, then he is disqualified from getting the membership of Parliament. Next, if he has ceased to be a citizen of India, if he is disqualified under any other law by the Parliament, if he has been convicted for promoting enmity between different groups, or for bribery offense, or for preaching and practicing social crimes such as untouchability, dowry, or sati, or convicted for an offense and sentenced to imprisonment of more than 2 years. Such persons are not suitable to get membership in the parliament. Then the broad responsibilities of the members of Parliament of Lok Sabha are legislative responsibility, that is to pass laws of India in the Lok Sabha. Next is the oversight responsibility to ensure that the executive perform its duties satisfactorily. Representative responsibility, that is to represent the views and aspirations of the people of their constituency in the Parliament of India. And next is the power of the pursive responsibility, that is to approve and oversee the revenues and expenditure proposed by the government. Next, we will see the Union Judiciary, that is the Supreme Court, which is defined in Article 124 to 147. The Supreme Court of India consists of a Chief Justice and 30 other judges appointed by the President. A judge of Supreme Court of India shall hold the office up to the age of 65 years. He can resign his office by writing a letter to the President. He can be removed only on the grounds of misbehavior or incapacity as per Article 124. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and must have been a judge of High Court for at least 5 years, or must have been an advocate of High Court for at least 10 years, or in the opinion of the President, he should be a distinguished jurist. Next, we will see the jurisdiction of Supreme Court. Supreme Court to be a court of record, Article 129. It has a power to determine its own jurisdiction and it has a power to punish for its contempt. This can be explained with a case. On 29th June 2020, Advocate Prashant Bhushan published a tweet about the Chief Justice of India, accompanied by a picture of a Chief Justice on a motorcycle. The tweet was something like this. The Chief Justice of India rides a rupees 50 lakh motorcycle belonging to a BJP leader at Raj Bhavan, Nagpur, without wearing a mask or helmet at a time when he keeps the Supreme Court on lockdown mode, denying citizens their fundamental right to access justice. Actually, this was a sort of disrespect towards Supreme Court. So, a petition was filed against Prashant Bhushan and Twitter India on 2nd July, requesting the court to initiate contempt proceedings for the tweet, alleging that it will scandalize the court. On 21st July, the Supreme Court took suo motu cognizance of the petition and initiated contempt proceeding against both Prashant Bhushan and the Twitter. And now, the suo motu cognizance is a Latin term which means an action taken by a government agency or court or other central authority on their own apprehension. So here Supreme Court has taken the case against Prashant Bhushan and Twitter for disrespecting the court. So that means Supreme Court has the power to punish for its contempt. That is the first jurisdiction, Supreme Court to be a court of record as per Article 129. It has the power to determine its own jurisdiction and the power to punish for its contempt. Next comes the original jurisdiction as per Article 131. This refers to the cases that directly originate in Supreme Court. The Supreme Court has got original and exclusive jurisdiction in any dispute. If the dispute is between the Government of India and one or more states, or between the Government of India and any state on one side and one or more other states on the other side, or between two or more states. Next comes the advisory jurisdiction, Article 143. The President of India can refer any matter that is of public importance or that which involves interpretation of Constitution to Supreme Court for advice. That means Supreme Court can act as an advisory body to President. Next comes the appellate jurisdiction, Article 132. The appellate jurisdiction of the Supreme Court is extensive. It is the highest court of appeal. Supreme Court is the final authority on questions involving interpretation of the Constitution. The appellate jurisdiction of Supreme Court can be invoked by a certificate granted by the High Court concerned under Article 132(1), 133(1) or 134 of the Constitution in respect of any judgment, decree. Decree means an official order that has the force of law, or final order of a High Court in both civil and criminal cases involving substantial questions of law. Then what is substantial question of law? It is a question that must be answered by applying relevant legal principle to interpretation of the law as to the interpretation of the Constitution. Okay. Now there are three types of appellate jurisdiction. First one, appeal lies to the Supreme Court in civil matters. If the High Court concerned certifies, as per Article 133, that the case involves a substantial question of law of general importance. If the High Court feels that the case needs a substantial question of law, then that case can be given appeal in Supreme Court, and that in the opinion of the High Court, the said questions needs to be decided by the Supreme Court. Next, appellate jurisdiction is possible in criminal cases. In criminal cases, an appeal lies to the Supreme Court if the High Court, and this is defined in Article 134, if the High Court has reversed the decision of the acquittal of an accused person made by the lower courts and sentenced him to death or to imprisonment for life or for a period of not less than 10 years. That means if the subordinate court of the decision taken by the subordinate courts on a particular case has been reversed and that particular person has been sentenced to death by the High Court, then that case can be gone for appeal in the Supreme Court. Or if the High Court has withdrawn the case for trial from any of its subordinate court before the trial in the subordinate court is over and has convicted the accused person and sentenced him to death or to imprisonment for life or for a period of not less than 10 years. That means if the case which is filed in the subordinate court has been withdrawn from the subordinate court by the High Court before the trial is complete and the High Court is sentencing that person to death or imprisonment, then that case also can be gone for appeal to the Supreme Court. Or the High Court should certify that the case is a fit one for appeal to the Supreme Court. In these three cases, you can go for an appeal in the Supreme Court. And the third one is jurisdiction under constitutional matters, which is defined in Article 132, 133 and 134. Next is the writ jurisdiction or enforcement of fundamental rights, Article 32. An individual whose fundamental right is violated by the state can directly approach Supreme Court for enforcing his fundamental right. The Supreme Court is the guardian of individual liberties and fundamental rights. For enforcement of fundamental rights, it can issue writs in the nature of habeas corpus, mandamus, certiorari, prohibition and quo warranto. Then what is habeas corpus? The Latin meaning of the word habeas corpus is to have the body of. This writ is used to enforce the fundamental rights of individual liberty against unlawful detention. Through habeas corpus, Supreme Court or High Court orders one person who has arrested the other person unlawfully to bring the body of the latter before the court. Facts about habeas corpus in India. The Supreme Court or High Court can issue this writ against both private and public authority. Habeas corpus cannot be issued in the following case: if the detention is lawful, when the proceeding is for contempt of a legislature or a court, if the detention is by a competent court, or if the detention is outside the jurisdiction of the court. In these four cases, habeas corpus cannot be issued. Next comes a mandamus. The literal meaning of this writ is we command. This writ is used by the court to order a public official who has failed to perform his duty or refused to do his duty to resume his work. Besides public official, mandamus can be issued against any public body, corporation, inferior court, tribunal or government for the same purpose. That is, if they are failing to perform their duty or refusing to do their duty. Next is prohibition. The literal meaning of prohibition is to forbid. A court that is higher in position issues a prohibition writ against a court that is lower in position to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Next is certiorari. The literal meaning of the writ of certiorari is to be certified or to be informed. This writ is issued by a court higher in authority to a lower court or tribunal, ordering them either to transfer a case pending with them to itself or quash their order in a case. It is issued on the ground of an excess of jurisdiction or lack of jurisdiction or error of law. It not only prevents but also cures for the mistakes in judiciary. Next is quo warranto. The literal meaning of the writ of quo warranto is by what authority or warrant. Supreme Court or High Court issue this writ to prevent illegal holding of a public office by a person. Next comes the appeal by special leave as per Article 136. Special leave petition gives extraordinary power to Supreme Court because special leave petition can be filed only in Supreme Court. With respect to any judgment, order or decree issued either by High Court or any other subordinate court, the special leave petition can be filed in Supreme Court. That means direct intervention of Supreme Court is requested directly into this matter. I can explain this with a case that happened in Andhra recently. We know as per the 73rd and 74th Amendment, Chief Election Commissioner is in charge of the local body elections in any state, and it's the governor who elects the election commissioner. The governor acts as the advisor of the chief minister. They discuss and finally they decide the chief election commissioner. Now, what happened was Mr. Ramesh Kumar was appointed as the election commissioner of Andhra by the earlier government headed by Chandrababu Naidu, Telugu Desam Party. After that, in 2019, the YSRCP came into power and Mr. Jagmohan Reddy became the Chief Minister of Andhra. And what happened was, the local body election was to happen in Andhra, but on March 15, 2020, Mr. Ramesh Kumar deferred the local body elections, stating COVID reasons without consulting the Chief Minister or Chief Secretary. So government got angry with this decision and they bought an ordinance, and the ordinance was issued by the governor to reduce the tenure of the election commissioner, and he has to step down. By this time, Andhra government appointed Justice Kanakaraj as the election commissioner of Andhra. So what Ramesh Kumar did, he approached Andhra High Court, and High Court gave judgment in favor of Mr. Ramesh Kumar, and High Court ordered government to reinstate Mr. Ramesh Kumar as the Chief Election Commissioner. But government approached Supreme Court and against this verdict, and the Supreme Court told this matter has to be settled by the High Court, but still the case will be there at the Supreme Court. Later, government was delaying in reinstating Mr. Ramesh Kumar, so he again approached the High Court and filed contempt petition. Contempt petition means the order given by the Andhra High Court is not followed by the government. That is why he filed the contempt petition against the government in the High Court. By this time, again the Andhra government approached Supreme Court and filed special leave petition to look into this matter. That means here the order issued by a lower court is challenged by the government in the Supreme Court. That is appeal by special leave, which is defined in Article 136. And that's all in this presentation. Thank you, and these are my references.